YouTube. The Minnesota State Supreme Court is facing a very interesting dilemma, and that is when the legislature passes a ballot measure to the people, do they, or the Secretary of State, who's had that ability since 1919, able to title the measure? The marriage ban on Minnesota's Constitution would be limiting the rights of marriage to gay and to heterosexual couples. And then the voter ID law that they want to pass, that they pass to the people, will say changes to in-person and registration, in-person voting and registration, which is exactly what voter ID is. The question facing the Minnesota State Supreme Court is this: does the legislature have the ability, according to the Minnesota State Constitution, to title ballot measures that it passes to the people? Now, the Secretary of State often titles the ballot measures. In many states, where they are able to put them on the ballot as a constitutional amendment or period. As with Proposition 8, it was titled such, Proposition 8. And it was also, actually, it was what its description was: eliminates the right of same-sex couples to marry. And that's exactly what Proposition 8 did. Now, the Minnesota State Supreme Court, I feel, since the Secretary of State has had that power given by the state constitution since 1919, they should uphold it, I feel, because of the fact that that is what has been outlined in the Constitution of the state. To give the legislature the ability to pass, the fact is, the legislature writes the law, and most often they title it, yes, but they title the laws that they pass. When given something to the people, I feel that, one, they should definitely have the text of the amendment on the ballot, so that there is no confusion of what they're voting for. Many times ballot measures may be confusing, and people may not know what it does. And if they don't know what it is, then if they don't vote on it, then it's sometimes it's a no vote. But I wonder, one simple thing is, how can the legislature now say that we want to title this? Well, it's because they want it to pass. They want to title it in a way where it may be simply more neutral and swing the moderate crowd to a yes vote as opposed to a no. Unfortunately, I do believe that the Minnesota amendment may pass. I really am. What I'm thinking is, Minnesota can very well reject that measure, and I really am pulling for them to do so. I'm also hoping that Washington will approve Referendum 74, and that Maryland will approve marriage equality there. Those three wins, I think, would be a resounding moment in the LGBT fight for equality. So now I put this question to you: where would you put your where would you place your bet? Should the legislature give a title to a ballot measure because it passed it to the people, and one of the judges said it's a conversation between the people and their legislature? Or should, since the Constitution enumerates that right to the Secretary of State, should the Secretary of State remain the only one who can title a ballot measure, but also take the court's suggestion that the text of the ballot measure be on the ballot? I feel that that is the best option as well, regardless of who titles it. But I feel that since the Constitution expressly gives this power to the Secretary of State, he or she shall remain the one to title such measures. Where do you place your vote? Have a great day, YouTube, and I'll see you later.